Just one question. I'm not sure that you quite answered Justice Kagan when she was asking you about your formulation of the major questions doctrine, because she described it as, in Brown and Williamson, the FDA staying in its lane. What? The FDA can regulate tobacco. Or if you think about the eviction moratorium case from earlier this term, it was what? The CDC can regulate the landlord-tenant relationship. Here, if we're thinking about EPA regulating greenhouse gases, well, there's a match between the regulation and the agency's wheelhouse, right? So you're describing something a little bit different than Justice Kagan was asking you. You're saying when you look at the scheme, this is a really big deal. How do we decide that? That's a little bit different than a mismatch between the subject of the regulation and what the agency does.
So actually, Justice Barrett, I think it is a mismatch in this pretty much the same way, because I think if you look at the Clean Power Plan and that interpretation of the statute, the agency really isn't regulating emissions. It's regulating industrial policy and energy policy, right, that is going to have downstream emissions consequences. It's not actually saying, here's how you can reduce your emissions. It's saying, well, we can do the market differently in a way that we won't need you at all, and then, yeah, sure, you won't have the emissions from the plant. I think that is just taking it on to again, a fundamentally different level in just the same way as Brown and Williamson and those precedents.
Thank you.
Thank you.
Thank you, counsel. General Preliger, why don't we take a 5-minute break?